Good morning. Welcome back to Relativity Fest. My name is David Horrigan. I'm Relativity's Discovery Counsel and Legal Education Director, and it is my honor and privilege to welcome you to the 8th Annual Relativity Fest Judicial Panel. Back in 2013, we got together and started pondering what it would be like to try to gather the most knowledgeable and well-renowned judges in the fields of e-discovery law and its related disciplines of data privacy and data protection to join Relativity Fest to talk about the law and how it relates to the society at large. Well, for the 8th time, we're back here. Some of the jurists you're about to meet are judges you've heard before. And some of them have been with us since the beginning. And we're all wishing we could be back in Chicago, but we're glad that we can be more inclusive and have a Relativity Fest where a whole lot more people can attend and a whole lot more people can experience the wisdom of these judges. Let's welcome the judges. We have an incredible diversity of judicial thought with us here on the judicial panel. Our first judge, and they are listed in alphabetical order, is the Honorable Nora Fisher. She is United States District Judge. She is actually Senior United States District Judge for the Western District of Pennsylvania. Judge Fisher was confirmed to the appellate bench by a unanimous vote of the United States Senate, something that seems rare these days. She is a former legal editor, something near and dear to my heart as always. She was with us for the first judicial panel, and she's been with us for every single one of them, except for last year. And so we're really pleased to have her back. Judge Fisher has a special interest in patent litigation. She's a former litigator herself, a former law firm partner as well, and she also was very instrumental in the Western District's e-discovery special master program. Judge Fisher, welcome back to the judicial panel.
Happy to be here. Thank you.
Next is the Honorable William Matthewman, United States Magistrate Judge for the Southern District of Florida. Judge Matthewman brings a great perspective to our discussion in that he is not only a former practicing attorney, he is a former police officer. He has represented both criminal and civil defendants and plaintiffs. And so he's seen criminal law from both sides and he's seen civil law from both sides. He was a well-known litigator. He appeared on both 48 Hours and on Dateline for one of his cases while he was still practicing. And he brings a vast judicial experience. We're going to talk about a law review article he wrote shortly. And he had two very important e-discovery decisions last year. We discussed on last year's judicial panel. Judge Matthewman, welcome back to the judicial panel.
Well, thank you. Glad to be here.
Next is Judge Victoria Mccloud. Judge Mccloud is Master of the Senior Courts, Queen's Bench Division. She joins us from the Courts of England and Wales. In addition to her legal training, she is a chartered psychologist and she is on the law faculty of the University of Oxford. She holds a PhD. And Judge Mccloud, because one of the great things about Relativity Fest is that we gather lawyers and judges and technologists, paralegals from all over the world. And so we get to learn about different cultures, different nations, and different judicial systems. So we have been calling you Master Mccloud. That was always the form of address. And now your title hasn't changed, but now the form of address is Judge Mccloud. What happened there?
Well, thanks, David. It's great to be back. It's probably a sign of me being a bit rebellious in the sense that I quite like Master as a title, and of course that remains my title. But there have been some people who feel that Master is perhaps a gendered title, and also that it's perhaps getting a little antiquated. We have an informal mode of address in Britain anyway, so that if you run into a judge socially, you might just call them judge. So I thought that I would simply make it clear that I'm happy to have people and encourage people to simply adopt that informal title effectively as a type of modernization in effect. And I think the bar are finding that a comfortable thing to do. It may catch on. It's entirely unofficial, or it's about as official as it is simply because I'm doing it, and I don't make policy. So it's a degree of eccentricity, if you like, on my part, or perhaps a degree of modernization. You could put it either way.
Modernization and cutting-edge application of the law. Thank you, Judge Mccloud. It's an honor to have you back with us. Justice Tanya R. Kennedy, my apologies. Here, after I said we'd be introducing all the judges in alphabetical order, I deviated. That is not any problem in the programming. It is my technical issue because I see the judges on the screen and Justice Kennedy was in a different order. Justice Tanya R. Kennedy, Associate Justice, Appellate Division, First Judicial Department, New York Supreme Court. Justice Kennedy brings us a diversity of thought, a new perspective, in that she is our state court representative. We have Judge Mccloud from the courts of England and Wales, but we in the world of e-discovery tend to focus on the complex commercial litigation that really happens a lot of the time in federal court. However, at our own peril, we ignore the state courts because that's where the majority of litigation are. So, Justice Kennedy, we really appreciate your perspective. In addition to your current appellate judicial service, you, of course, have been in the civil courts, the family court as well, the criminal court, and your service to the community is well known as you are the former president of the National Association of Women Judges. Honorable Tanya R. Kennedy, thank you for coming back and joining us.
Thank you, David. It's great to be back.
And finally, because we're going in partial alphabetical order, the Honorable Xavier Rodriguez. Judge Rodriguez, as I mentioned, has been with us since the beginning. He is also the one jurist who has been with me on every single judicial panel. He brings a unique perspective as well because he straddles the federal and the state courts. Not only is he United States District Judge for the Western District of Texas, he has also served as Associate Justice on the Texas Supreme Court. He has also served the nation as a reserve officer. Judge, thank you for your service. He is also a member of academia. He serves as an adjunct professor of e-discovery at the St. Mary's University School of Law. Judge Rodriguez, welcome back to the judicial panel.
Thanks for the invitation.
And we're going to take a quick look at some of the legal topics we're going to be discussing today. If we were there in Chicago on the big stage with the Jumbotron, we would be running slides throughout the discussion. And we actually did run slides last year. However, we want you to be able to feel as though you're interacting with the judges. And more importantly, we want to make it easier for the judges to interact among themselves and with me, your humble moderator. So what we've done here on this one slide is told you just to frame the discussion and let you know where we're going, what we're going to be discussing today and some of the cases involved. The first will be the role of judges in e-discovery. We're going to talk about just how active they should or shouldn't be. We'll move into the judge as referee, and we're going to talk about some entertaining cases, and that's entertaining in a bad way. We'll move on to cooperation and e-discovery, talking about time zones, sanctions in e-discovery. We cannot have a judicial panel without the judges letting us know what happens for bad behavior in e-discovery, and we'll round it out with a discussion of biometric data. The one thing you don't see on this slide is something I'd like to kick off this discussion, because if we didn't, it would be the elephant in the room. And that is the COVID effect, how the pandemic has affected each of the courts. Judge Fisher, why don't we start off with you? And we'll just keep this a brief discussion before we get into the more legally related topics. But this is a legal related topic because it involves how people have practiced the law. Judge Fisher, we saw a dip in civil filings right around the time of the pandemic beginning last year, and then they bounced back up. What's been your experience in the Western District, both from volume and from what you've had to do in the court?
Well, thank you, David, for the question. I have to say, we're an anomaly. Many of the courts saw a dip. We did not. In fact, we have the highest number of civil filings that we've had in this court since 2002. In addition, we have the highest number of criminal cases both last year and again this year than we've had in the history of this courthouse. So I don't know what it is that's causing practitioners to come here left and right and file their cases, but we've seen a major uptick here in our court. Fortunately, since I first appeared on this panel, we've had a lot of reinforcements. At one point, we only had 4 active district judges. We're now a complete complement. So that's making things a little bit easier. We are using video conferencing of various styles, and we're using it routinely. Our chief keeps a running tally. I think as of earlier this week, over 5,000 proceedings have been done by way of video. Our practitioners have adopted well. They like it. They want us to keep it. I know the Court Administration and Court Management Committee nationally is going to be looking at this issue at an upcoming meeting in December. The other thing I would say is the prisoners like it. And indeed, earlier today, I had 2 criminal sentencings. And I can tell you for a fact, many of our criminal defendants will tell us, number one, they like the video. They can see me more up close and personal than in my courtroom, which is very large. And in addition, they get to have a lot of family and friends be participatory by way of video. We've had as many as 16 family and friends from all over be able to participate. So that's generally what's happening here in the Western District. We are getting back to trials. We just had one that concluded successfully. I understand here in Pittsburgh, we have 34 cases split evenly, civil and criminal, coming up between now and the end of the year. Our other divisions, too, are operating and having trials. Of course, we have lots of social distancing. Masks are mandatory in Pittsburgh and in all 3 of our courthouses. People generally comply. Knock on wood, we've had few COVID cases here in our court, but we've had some.
Thank you, Judge Fisher. That's fascinating. We tend to think of Zoom, Microsoft Teams, all these video conferencing systems as impersonal. And it's fascinating that A, you didn't have a dip in cases, and B, that the litigants and the criminal participants were finding it more impersonal. And it's great that the family members got to be there as part of it. Justice Kennedy, moving to the state courts of New York. What's been your COVID experience?
I'm going to address my experience in the appellate division. I'm happy to say that once we resumed oral argument after Labor Day, we did not have a backlog of cases from the prior term. We now sit in person with the 5-member bench 4 days a week. All attorneys and justices are required to wear masks. There is a plexiglass cover in front of each justice. I sat yesterday, and I must say that when we all saw each other, we just hugged because it was so great to see everyone. We haven't seen everyone. And certainly, there are times when an attorney may ask a justice to repeat the question because they didn't hear, because of the mask. It's an impediment. However, it's minor and it doesn't impede on the quality of the oral argument. Unfortunately, as it relates to the conferences that we have, pre and post-argument conferences relating to appeals, and then our weekly agenda conferences with the 19 members of the bench, they are virtual. But in spite of that, we really work hard to further congeniality. And certainly also with respect to the admission ceremonies for the new attorneys, they are virtual. And I feel bad for them because they miss out on that experience in seeing our majestic courtroom, because there is nothing like the personal touch. But I really have to commend the presiding justice, the entire staff, particularly the technology staff, for the ease in converting to virtual and hybrid when necessary. We're holding our own, David.
Thank you, Justice Kennedy. Moving to Miami, Judge Matthewman, what's the situation down there?
Well, here in the Southern District of Florida, and we run basically from Vero Beach to Key West. It's a long district along the coast. I'm in the West Palm Beach division. We've been extremely busy. And luckily, with the technology, we have been able to keep things moving quite well. About 2 years ago, I never heard of Zoom, and now I use it on a constant daily basis. It really is amazing. And I do agree with Judge Fisher, because I find the lawyers, the participants really have taken to the Zoom and the video conferencing platform. It has been a real eye-opener for me, and I intend to use it as long as possible. I agree, in criminal cases, it's been excellent. I've had evidentiary hearings. I've had lengthy hearings. I've had all types of matters, initial appearances, all types of things by Zoom, and it works very well. And a lot of times, a defendant will be in another jurisdiction or incarcerated somewhere far away from the courthouse, and it makes it much easier on the defendant, on the marshals, and on everybody. So I think it's very, very good. We are kicking back into trials now. I just finished a civil jury trial just recently, within the last couple of weeks. It went very well. We were able to get a jury with no problem. We had safety. We did it as safely as we could. The jury was phenomenal. Very few people tried to get off with a COVID excuse, and the ones who did, it was very legitimate. We were able to get a verdict very quickly in a large dollar case, and it really was very good. So I think there's been a silver lining to the pandemic, as terrible as it's been to this country and to a lot of people. The advantage is that we've been forced to adopt technology that we never would have adopted before, because human beings are pretty complacent, and you want to keep doing things the way you've been doing them. We were forced to do this new procedure, remote procedure. It's working great in depositions. It's working great for me in search warrants and all types of other applications. It's working really quite well, and pretty much everything leading up to the trial, I'm trying to do by Zoom. And I have found from feedback that most lawyers and most litigants really do appreciate it. So we are doing very well down here, even though the Florida is a hotbed for COVID. Our district is keeping everybody as safe as possible, and we are dealing with an increased caseload very well.
Thank you, Your Honor. Judge Mccloud, let's cross the Atlantic. What's been the effect for you?
Well, it's changed a lot, actually, over the course of the pandemic. Initially, we just scattered to the four winds and worked entirely remotely, Zoom or phone hearings, and if you like, made the best of it at sort of very quite short notice. And I'd be having hearings with a backdrop behind me here in my kitchen, which I've taken down now, a physical backdrop with books that people thought I was very learned because I had lots of books on it. And we found those went very well. I had some good experiences, some not so good. One that didn't go well, a hearing that I actually stopped partway through and said, this doesn't feel right, was where there's no lawyers involved, where you've got allegations of abuse on one side, physical, emotional abuse, allegations of defamation on another, a party not wanting to look at the other party because they're scared, the other person insisting on being looked at because of a particular disability that meant that he wanted me to see his face so that I would interpret his expressions correctly. The whole dynamic was wrong. And I called that hearing to a halt in favour of saying, come back at a later date when we're physically in court. But I think where I've had lawyers involved and where the cases are more legal or technical, I think Zoom's worked very well. Trials I tended to have in a physical court. I would make arrangements, go in. We'd have a very large courtroom, specially booked, social distancing. And if there were too many people, we could book a separate second courtroom with a video feed for people to watch. And one interesting side effect actually of having a lot of remote hearings actually has been greater press attendance, because it's quite easy just to add someone to a Teams or Zoom hearing just to observe, whereas I guess a member of the press has to come into the court and sit in the courtroom in the normal run of things. So actually, ironically, perhaps press access was actually more extensive than it might normally be. Since July, I've been back to normal. We don't have any restrictions anymore in terms of masks or anything of that sort. So masks are optional in court. I let people do what they like. I don't personally bother. I have a nice big space to work in. And people are very happy actually to be physically back in court. I've had a couple of trials since July. Recent one, a cause of death trial with someone dying on the railway. Much better for that, I found, actually, to be in court, and the advocates were thrilled to be back and thrilled actually to be holding paper documents, having been staring at PDFs for a year and a bit. So it's been good in places, not so good in places, and very much returning to normal here now, really.
Thank you, Judge Mccloud. Judge Rodriguez, I want to get your take on this, but I'd like to ask the entire panel. There was a fascinating point there that the remote proceedings have actually increased press attendance. Are we doing that in the state? Are you getting requests from the media to join Zoom conferences and the like? Has anyone had that experience in the States?
Yes, I have. And to that end, they'll reach out directly to chambers. My law clerk will give them the link so that they can participate. They're told in advance that they really can't participate by speaking. They've adhered to that. And I do agree. I think that it's more prevalent to have press appear by way of the technology than necessarily in person, although I think we do have a couple of good press reporters here. There also is nationally, David, a pilot going on where judges and litigants can decide that certain cases, and particularly arguments, motion hearings and the like, status conferences, can be available to a larger mass of people. And to that end, it's audio only. I know our court's one of the pilot courts, but I don't think, frankly, it's been used as much because everybody has to agree. Whereas, for example, the city of Ferguson case, most people know about that litigation. It's pretty routinely used there, and they get a lot of people who dial in. So to that end, yes, there's been a definite plus in not only the press, but also the public having a little more access.
Thank you, Judge Fisher. Judge Rodriguez, what the pandemic has done in your court?
Yeah, so in the Western District of Texas, civil filings have pretty much remained constant and not increased a little bit, primarily due to my colleague in Waco, who I believe now leads the nation in patent filing, patent infringement cases. And so on criminal matters, we have a slight dip. That's primarily attributable to the change in administration. The many deportations now were taking place administratively rather than through criminal prosecution that had previously been done. Been hit and miss all over the district. Some of my colleagues never stopped trials, notwithstanding the pandemic. I thought that was rather problematic. There was various outbreaks throughout Texas. In San Antonio, we have had stops and starts as our pandemic numbers improved. We opened back up and then we closed back down. And so it's been back and forth. We're currently closed, but opening again on October 4th. In the interim, it's been Zoom world, just like my colleagues have described here. It's basically worked. I don't think it's worked for everything. I haven't had the success on evidentiary hearings that some of my colleagues have had. And then for some evidentiary matters in criminal cases, I've actually required us to have a in-person court appearance. I had a motion to suppress on a criminal matter. The law enforcement officer was lying. I'm not sure I would have ever detected that on Zoom, but it caused me some quandaries when I saw him in person and how his total body behavior was reacting. As a result, I asked for documents after the hearing was over, and 6 days later, the government filed a motion to dismiss the indictment for lack of confidence in their witness. I'm not sure I would have gotten that in Zoom world, but other cases, and we've had bench trials going forward. I've had witness testimony in all forms, live in person in the courtroom, via Zoom, via deposition testimony, via previous video that's applied. I think Judge Matthewman hit it right on the head. It's caused us to think about new and creative ways to bring in. I'm waiting for a hologram. I want to see a hologram in the courtroom. But it's an interesting new world.
Indeed it is. Thank you, Judge Rodriguez. Throughout this discussion, you can see that the role of the judge is an important theme that we have for this year's judicial panel. Each one of the jurists has told us how they've dealt with the pandemic, how it's affected what they do in their courts. And to sort of frame the legal discussion on this issue, we've pulled out 2 law review articles, one of them written by Judge Matthewman and one of them a response in the University of Florida Law Review Forum written by me. And Judge Matthewman's article was Towards a New Paradigm for E-Discovery in Civil Litigation, a Judicial Perspective. And it had 10 core components. One of its core components was active participation of judges in the e-discovery process, and I should say discovery process, and prompt resolution of any discovery disputes by the court. You may recall that after the 2015 amendments to the Federal Rules of Civil Procedure, Chief Justice of the United States John Roberts came out and was talking e-discovery, believe it or not, in his year-end report from the court. And he was specifically mentioning discovery disputes. So there you have one hand. Yes, the new Rule 1 calls for judges to be actively involved. I think many people support Judge Matthewman's position. I might note that Judge Peck also wrote one of the responses along with me. And mine was entitled Activist Judges, Technology Rule 1 and the Limits of Judge Matthewman's New Paradigm for E-Discovery. Judge Peck agreed with Judge Matthewman, but he said it was quote unquote unfortunate because court resources are limited. There are 3 quick cases on this one. Before we get into the cases, those of you who were with us for the first judicial panel in 2014 may remember that the Honorable David Waxy from the District of Kansas had what he called a simple way of resolving these disputes. He would put them on video camera. And by the way, when you check the CLE resources, the link is available. Both law review articles are there. Some of the cases are there. And you can click this link where you will see Judge Rodriguez and Judge Fisher and I joining Judge Waxy as he talked about the fact that he would have them videotape their conferences, and suddenly things got solved. And he mentioned that he's yet to see a videotape. So Judge Peck tells a colleague about this, and wouldn't you know, Judge Peck's colleague came back to him and said, "Thanks. Guess what I just got in the mail? Videos." So I guess it takes it. But in Avista Management v. Wausau Underwriters, U.S. District Judge Gary Presnell of the Middle District of Florida got sick of counsel's inability to set a 30B6 deposition. So here is the exact wording of his order. Quote, "Each lawyer shall be entitled to be accompanied by one paralegal who shall act as attendant and witness. At that time, counsel shall engage in one game of rock, paper, scissors. The winner of this engagement shall be entitled to select the location for the 30B6 deposition." But wait, it gets better. In Azonis v. Suffolk Bus Corp., an Eastern District of New York case, Judge Gary Brown noted the precedential value of rock, paper, scissors. But he said, quote, "Unfortunately, rock, paper, scissors involves human variables that render it less than ideal as a dispute resolution device. The instant matter may be resolved in this court's view through the use of coin flipping, a commonly used practice that employs an item manufactured to the exacting standards of the United States Mint." Master Mccloud, I am reaching across the Atlantic in hopes of reaching sanity. You've heard what Judge Waxy had to do. You have heard what Judge Presnell had to do. And of course, Judge Brown, it comes down to a coin toss. We gather much of our law from our English brethren. What do you think? Do you have to put up with this kind of stuff? And if so, how do you deal with it?
Yes, I mean, we get a lot of disputes. The judges here are can be very involved in the detail of e-disclosure disputes. I mean, I've never had a situation where I've had to toss a coin. One could probably extend the coin toss or the paper, scissors, stone approach actually and just determine the case that way. I mean, that might be an alternative form of dispute resolution that would save a lot of judicial resources. But leaving that aside, I've never been in that position. I have had a case where I had to determine the exact search terms on multiple servers, all of which were in Norwegian, which made for some interesting Boolean logical search terms of sort of things that personally I couldn't pronounce. And I do remember I had one where one of the search terms that was of some importance was the expression a cup of tea, which I thought was very English and very appropriate, involving a politician. I think the nearest I've come to a sort of intellectual nightmare actually is not, it's not really a funny one. It's actually sort of more of an intellectual nightmare. Was a situation where confidential data, electronic data, was allegedly leaked by hackers to the press, and a claim was brought to try to have delivery up orders from a national newspaper. And the national newspaper declined to give any disclosure because it was felt that that an appropriately expert forensic person in IT might be able to identify what they were calling their journalistic sources from any form of e-disclosure. And we were in a situation where we were going to have to resolve that with expert evidence. And then there was a question of, well, what type of expertise? Do you allow both sides an expert? Because if you do, you're actually then disclosing the data to the party, to the other party. And of course, the newspaper was concerned about the sources being revealed. We never actually, like all the best nightmares, we never actually resolved that one because the parties settled. But there was definitely an unexpected tension there between any kind of e-disclosure duty and the protection of journalistic sources.
Thank you, Judge Mccloud. An interesting perspective. We're about the halfway point of our program. And so now for those of you seeking continuous legal education credit for the judicial panel this year, your CLE code word, or code phrase, I should say, is 256 pages. Once again, the code phrase is 256 pages. And I see some chuckling along the judicial panel, and that is because those of you out there who are students of e-discovery law will know what that reference means. It's foreshadowing to a case we'll be covering in the second half of the program. All right, let's go stateside, starting with you, Judge Rodriguez. We've heard the horror stories of Avista and Avonis from the case law. You were there live and in person to hear Waxy and Peck going back and forth. Do you see these horror stories? And if so, how do you deal with them?
So, I think every judge sees these horror stories to one degree or another. Just the bigger question is how much judicial intervention should take place. And so before the dispute, how much do we get involved? And there, I think that the problem may be, do we start putting thumbs on the scale as judicial officers by asking the parties, certain questions about sources of data, custodians? Do we start introducing areas that the parties themselves haven't thought about? I'm always a little concerned about whether we're putting thumbs on the scale by sort of directing the parties. Oftentimes I'll have my Rule 16 conference the first time that the lawyers are actually in the courtroom before a judge, and I'll start making some inquiries, and I notice that the parties are writing frantically, like I'm introducing new topics that they haven't given previous thought to. And then I pause thinking, God, am I talking too much?
Good point. Judge, thank you for that. And also you gave a great segue because I am planning a judicial poll in a few moments. And it's basically going on one side where you have Chief Justice Roberts, and I believe you have Judge Matthewman, because it's one of his core components, calling for an active judiciary. I sense, Judge Rodriguez, that you're not so sure how active the judiciary should be. And, in this law review article, I quoted you from a Relativity Fest Judicial Panel on TAR protocols and whether, I think you used the term pontification, people seeking them. So can I take it that maybe you're for a little less judicial involvement? Not completely hands off, but not babysitting either.
So one, we don't have time for babysitting. There's just too many cases. Then two, going back to the resources, I don't know the case as well as the litigants, and the judge will never know the case as well as the litigants. And so I won't know just what the repositories are, where the servers are, what type of servers. Unless I'm going to start spending a day with the parties to understand their data. I'm really oftentimes making uninformed decisions in the process. And so I think judges need to be cautious about how interventionist we become. Now, at the same token, it's not a completely hands-off approach. I think we need to be guiding and monitoring to some extent to make sure that the parties are moving forward and that we try to anticipate problem points before they become too unsurmountable. There's a fine line, and it depends on each case, I believe.
Makes perfect sense. Thank you, Judge. Justice Kennedy, you're, of course, on the appellate bench now, but think of your days in a trial court and just generally, how active do you think judges should be in the discovery process?
Let me say that I certainly agree with my colleague, Judge Rodriguez. I think that judges should really play a limited role in discovery and to become involved to the extent of ensuring that the case proceeds in an efficient and timely manner. And I think that the degree of involvement will depend upon the circumstances of each case.
Thanks. Judge Fisher, how about it? How active should judges be?
Well, I tend to agree with Judge Rodriguez and Judge Kennedy in their sentiments. And similarly, I've had the instance, Judge Rodriguez, where I feel like I've had to pull back because before coming on the bench, I was 30 years a trial lawyer. And sometimes I wonder, why didn't counsel think of this, that, and the other thing before they come in and talk with me about the case? Be that as it may, I think we all take to heart in the Western District our role as case manager. And to that end, case management conferences in our court tend not to be flybys. In other words, the judges will ask, about the case, how it's developing, who the players are, and the like. And so counsel should be prepared to answer those kind of questions. If you look at our website, we have a pretty detailed section that deals with e-discovery. That was thoughtfully put together a number of years ago as part of our e-discovery special master program. My colleague next door, Judge Conti, had a lot to do with that, along with me and a committee of practitioners. And we do point counsel to the fact that there are checklists and other materials that they can use on our website to the extent that they are not very familiar. Now, the other thing that we've adopted now going back several years is we do check-ins on the discovery front. I do it by joint written status report to the court. And so the attorneys need to confer and they need to give me a joint written status report, what they've been up to since I saw them at the initial case management conference. I read those, my law clerk does. If I see a problem developing, we send out an email, we schedule a conference, we have a court reporter involved. In addition to that, we say at the case management conference, if you need to reach out to the court, please do so. We would rather people do that than come in right away with a motion. One other thing I would say, and we might be a little bit different in that way, since about 2004 or 5, the discovery is handled by the handling judge. I know in many federal district courts, a magistrate judge is assigned, and the magistrate judge might do everything pre the trial date, including discovery disputes. We do not generally do that here. So as I tell counsel, if you bring a discovery dispute to me, it will be me who will be working on that discovery dispute. And frankly, my clerks are relatively young. They haven't had the years of practice outside the court. And so I look at the nuts and bolts of the discovery disputes. Of course, if we need to do it, we do the research, but they're hearing directly from me. And frankly, over the years, that's generally tried to tamp down the discovery disputes that I actually see. And as a court, we do not see a lot of e-discovery disputes. I don't know why that is, but we generally don't see a lot of them.
Thank you, Judge. Judge Matthewman, you've heard what your fellow jurists have to say on this issue. I certainly don't want to attempt to speak for you, although Core Component 10 does say that you think the judges should act an active role. And I don't think that you're speaking for the Chief Justice either. But I assume that you and the Chief Justice would say, yes, we call for active participation, but there are limits. No?
Yes, there are definitely limits. And I think that it depends on the facts of the case. I agree there should be no babysitting, and I agree there should be no hands-off provision. It's almost like Goldilocks and the Three Bears. You want to have the chords just right. I evaluate each case. I agree with Judge Fisher. I do a lot of joint notices. But what I find is, and what I've seen is that the discovery disputes really can sort of infect a case and they delay everything. So because discovery is not being produced or interrogatories are not being answered, it delays the deposition, it delays this and that. Then they come in asking for extensions and continuances and they're not ready for summary judgment, et cetera. So what I try to do, and it seems to work pretty well, is when there is a motion filed, and I require those only after personal conferral, I promptly address those. I look at them. I require a prompt response. I require the parties to confer. I set it for hearing, and I require a joint notice before the hearing. I would say 30 to 50% of those never get to the hearing because once they confer and file the joint notice, they've worked it out. And so it ends up saving a lot of time down the road. So my feeling is I agree completely with Judge Rodriguez that we're too busy to babysit litigants and lawyers. But I think I'm more inclined to very quickly deal with a discovery dispute, almost like a cut on your finger. You know, I've said this before, if you let it go and you don't treat it, it becomes infected and then you have to go to the hospital. As opposed, if you put a little Neosporin or an antibiotic and a Band-Aid, it goes away. And so I try from the outset to talk to the lawyers and say, listen, we expect cooperation, we expect professionalism, and we expect conferral and discussion. And I will often say, if there's good lawyers on both sides, I'm not going to see a lot of discovery disputes. And the ones that I do see will be legitimate. And I just find that if I jump into it quickly and get hold of the discovery issues early on, the case goes much more smoothly, and you don't run into these last minute issues where both sides are saying, well, I can't do my expert reports and I'm not ready for summary judgment and I need a continuance. I just find it works much better. So I'm sort of in the middle. I do believe that we do need to address them promptly, but I also agree that the lawyers need to do most of the work.
Thank you, Judge Matthewman. And viewers, you were here in person. You heard it first. The Neosporin doctrine of discovery in federal courts. That is a good one we should all remember. Justice Kennedy, we're going to put these concepts into motion in yet another case. This one is Island LLC v. JBX Pty Limited. This case is a discovery dispute, and it's one where I bet you'll all agree should have never ended up wasting the court's time, but it's an opinion in the courts. This is a trademark dispute over the name of some dietary supplements. Why is this important to us? Because counsel, who was in the Pacific time zone, sent a discovery response on the day it was due at around 11 something in the evening. The TTAB, where trademark administrative proceedings go on, is in Washington, D.C., in the Eastern time zone. The litigant involved who was serving the answers, and by the way, these were not a court filing, these were filing with the other party. This party counsel was actually in Montana. Why counsel's in California? Counsel could be anywhere. But so we've got the Mountain time zone, the Eastern time zone, and the Pacific time zone. So opposing counsel, noting that it was well after midnight in the Eastern time zone, said, sorry, counsel, your filing is untimely, therefore it should be stricken. Justice Kennedy, I wrote an article for Legal Tech News and the Relativity blog on this case, and Judge Francis, who many Relativity Fest people know, catch him in the e-discovery State of the Union, shameless plug for another session. Judge Fisher said if he got this dispute, he would send the litigants a copy of the Sedona Proclamation, the Sedona Cooperation Proclamation, along with a copy of Rule 1. However, another well-known legal commentator's response was, deadlines are deadlines. Justice Kennedy, where would you, not necessarily asking you for an advisory opinion on where you would come down, but generally, what do you think?
I'm going to answer it this way, David. First, I believe that the COVID-19 pandemic has taught us that flexibility and understanding are both key in that you must consider all of the circumstances now more than ever. Certainly, the question is, what, if any, prejudice did the other side suffer? And I beg to guess that none was suffered. So I certainly agree with Judge Francis. I know him, that cooperation rules the day, and that a deadline is not necessarily a deadline under the circumstances presented. The bottom line is that the responses were timely served, and it's important to note that in the case, the court indicated that the parties could have agreed to a specific time zone regarding the service of a discovery request and a response, and that if the responding party needed an extension of time because of the difference in the time zone, that they expected, it's that word again, cooperation between the parties. So certainly an unnecessary use of the attorney's time, resources, the court's resources, and certainly, unfortunately, will be billed to the client. But it's the lack of cooperation that occurred here.
Thank you, Justice Kennedy. Judge Rodriguez, I believe you're familiar with a case from this past January. It was the foreshadowing that came in the CLE code word. That is DR Distributors LLC versus 21st Century Smoking. It is yet another trademark intellectual property case involving the use of the phrase 21st century smoking. It's kind of interesting for you trademark buffs out there. You can certainly get the case off the Relativity blog, and we'll have it in the CLE materials. Judge Rodriguez, as you know, there was a 256-page sanctions order. And, you know, like everybody else in the e-discovery law world, I'm like, wow, you got to read this. And I'm looking. Now, I'm not to belittle what the parties did here, but I'm thinking, man, I've seen way worse discovery abuse than this. So, Judge Rodriguez, what is your take generally? It goes back to our theme on how active judges should be. And what do you think about the 256-page order?
It was long and it was repetitive. And that said, though, my real problems with the order, it raises an interesting point. In this case, the client lied to the lawyer. The client said, here's 4 disks. This has all the data you'll need to defend this case. And he gives the client four disks of data. Interestingly enough, it took 2 or 3 years before it becomes apparent that the emails that the client was using, which were on Yahoo and Google, and so they were on the cloud, right? And so the lawyer didn't understand. So there was a lot of technological incompetence here. The lawyer didn't understand that emails would not be found on those disks. Because that just copied the computer. The email that the client was using was stored in the cloud, and he didn't have that understanding. And the client was lying to him. The client all along knew he did not provide his lawyer that data. The judge goes off on the order, and I think this was an example of a little too much. He faults the lawyer for failing to issue a litigation hold notice. Well, in this case, it was apparent that the only person involved in this case was the owner of this company. So I'm not sure who this litigation hold notice was supposed to go to. Secondly, he faults the lawyer for not conducting custodial interviews properly. Well, again, this was basically a one-person operation. So there was a lot of principles in e-discovery law that we talk about that really were not applicable to this specific case. And so I'm a little troubled by the fact that the judge's knocking of self-collection here is going to now translate more universally in other cases that everybody's going to have the takeaway that self-collection is always and in every instance inappropriate. It could very well be that self-collection by a client is inappropriate in many cases, sexual harassment cases, antitrust cases, cases involving a one-owner operation, kind of a case like this. And as most of our e-discovery vendor friends here will realize, many e-discovery vendors are touting their products as a way to bring down discovery cost and allow corporations to self-collect. This case seems to not be grounded in reality with what's going on in the real world setting. That said, it has a couple of learning points. We as lawyers need to understand data, how it's stored and where it's stored. So it's a good learning point for that. Two, it's a very good learning point for, hey, when your client is lying to you and you become aware of that, you need to take some kind of rectifying actions. So those two overarching principles can be found buried in those 256 pages, but it's a hard grind to get there.
Thank you, Judge Rodriguez. And I would encourage our viewers who may be interested in the issue of self-collection and e-discovery to check out the recording of last year's judicial panel. On that panel, Judge Matthewman and Judge Rodriguez have a long discussion on this because Judge Matthewman, as I said, had one of the big cases of the year last year where e-discovery self-collection was an issue. So I encourage you to check out that recording. Judge Fisher, sometimes, even though in 2015, Federal Rule of Civil Procedure 37E2 came into being to make it really tough to get the most severe sanctions, the nuclear option is still there. And from your circuit, the Third Circuit, comes United States v. Brace. And so I'm wondering if you could tell us how you feel about the use of the nuclear option generally, and what do you think it takes to really get the nuclear option?
Well, thank you. And as the Brace decision in the Third Circuit and the underlying decision penned by Judge Rothstein point out, in that instance, and in both of those cases, it's pretty clear that the attorney continually violated court orders. And in effect, the judge had enough. But it's also clear that the judge continually warned that party that if you continue to flagrantly violate orders, there will be sanctions. And the judge properly went through what we call the polis factors, where under Third Circuit precedent, we have to go through these factors and determine whether or not, as you put it, the nuclear option is warranted or not. And so ultimately, Judge Rothstein also found in favor of the government there in granting summary judgment. And she did pen a very detailed, fine opinion in that regard. So there may be those instances, I think, when the nuclear option is warranted. But I also think in order for that nuclear option to stand, i.e. the dismissal of the entire case or even a portion of the case, it needs to be well documented what happened vis-a-vis the attorney, vis-a-vis the litigant. As Judge Rodriguez pointed out, it was pretty clear in regard to the DR Distributors LLC case that the principal of the business lied to his attorney, and that was a big problem, and it wasn't addressed, if you will, early on. But be that as it may, I know in my own instance, I've had a few instances where I got close, but decided ultimately to pull back. And in one of these cases, I looked at the entire situation, and it was kind of an oddball case involving eminent domain and the destruction of a piece of property and what this property was worth. And the litigants included a local municipality. And there, this particular municipality, which is up the river from Pittsburgh, a small place, had a part-time solicitor and had a secretary. And frankly, the part-time solicitor and the Insurance Defense Counsel left much to the secretary as to what should be done in terms of accruing the documents that were related to this case, including emails and the like. And in a nutshell, it was a botched job. So sad to say that in that particular case, rather than throw it out, rather than sanction the defendant, it was basically a discovery do-over. And everybody, if you will, learned by that. Ultimately, there was a motion for spoliation brought, which I denied for a number of reasons. And then ultimately the case went on to the summary judgment stage. And frankly, the defendants won over the plaintiff. And I can also recall another instance, early on in my tenure as a judge here, where I, in my words, got nuclear. I can vividly recall this employment dispute against a major corporation. And the plaintiff there had previously sued this same corporation and had recovered, was back at work at this corporation. And lo and behold, in the middle of one of the witnesses' testimony, she pointed back to her briefcase that she wanted to get a document from that briefcase so that she could refer to it. Well, it turned out that that document and many others in her briefcase had never been disclosed, never been produced, and the like. And sad to say, there the lead trial counsel left much to a younger associate to manage the case. And unfortunately, it blew up. Now, that case literally collapsed, and the case ultimately settled. And in my estimation, it settled for probably much more than what the case would have brought in front of the jury. So as a judge, when you look at these things, I think sometimes you do have to step back. You do need to make sure that you look at it from every side, because when you impose a sanction, particularly a dismissal, there's the attorney's reputation at stake, the law firm's reputation at stake, the rights of the client, and potentially there's a malpractice case. So I think any judge looks at that and looks at the whole picture and decides when and if that nuclear option should be made.
We're going to combine our last topic with closing thoughts. It's a lightning round. Each of you gets half a minute on this topic. You can comment on the case or give us whatever closing thoughts you would like. The case is Bardis v. Biomet, and it is the issue of biometric data. It has become a big issue. We've discussed it before in the Rosenbach case. In this one, they want Fitbit data from a plaintiff claiming personal injury for defective hep implants. We're going to start off with you, Judge Matthewman, on this one. You've been a police officer. As a lawyer, you were involved in cases dealing with technology. Spray tan comes to mind. Where do you draw the line on letting technology in the court versus data privacy rights, as in this case, or too much of a fishing expedition?
Well, these wearable devices or these mobile apps that show a plaintiff exercising or engaging in strenuous physical activity can be very relevant in the right case. But if you go too far, such as asking for location data and asking for things like heart rate that might not be relevant, then I think it's really stepping into the privacy realm. So I think that I see this a lot in criminal applications, search warrants and tracking warrants and extraction warrants, that type of thing. In the civil aspect, I haven't seen it as much. But I can say that if a plaintiff is alleging serious bodily injury, that they can't walk, they can't run, a Fitbit or app device that shows that they were doing just that after the injury very well might be relevant and proportional.
As they say, fair game. Thank you, Judge Matthewman. Justice Kennedy, we've each got about 20 seconds now for your thoughts on this or generally closing thoughts.
Sure. I agree with Judge Matthewman. I think that the discovery will depend upon if the material is relevant. And let me just say this. In all of these disputes, it's about using your common sense, being practical while following the applicable law, along with cooperation. That's key.
Cooperation comes back. Thank you, Justice Kennedy. Judge Rodriguez.
I'll spin this a little different. So when people are challenging these Fitbit devices and others, the challenge seems to be, Judge, they're not reliable. So, you got to remember, hey, one, we're just talking about discovery. So is it relevant and is it proportional? And then later when we talk about admissibility at trial, that's a completely different analysis. And so you might start thinking about, well, if it's going to be important enough and harmful enough that you're going to have to start thinking about what kind of experts you're going to have to challenge that reliability prong.
Thank you, Judge Rodriguez. Judge Fisher.
I'm going to take a pass on this particular one because I have this issue before me at this present time.
All right. We're going to read that case and let's talk about it next year. And finally, the final word with Judge Victoria Mccloud.
Well, I'll take 10 seconds, if that's all right. I agree with Judge Rodriguez. I think probably the key thing with biometric data would be obviously relevance, probative value. If it's the claimant, plaintiff's or defendant's data, then perhaps their rights to privacy are less than other people. And I agree that the disclosure test, of course, is different from whether what you're going to do with a trial, what orders you might make to protect privacy.
Thank you for a meaningful hour. On behalf of Judge Victoria Mccloud, Judge Nora Berry Fisher, Judge William Matthewman, Justice Tanya Kennedy, and Judge Xavier Rodriguez, and all of our employees across the world, as well as our partners and customers, thank you for spending part of your time with us. Enjoy the rest of Relativity Fest.